Any mention?
Lordship, I beg to mention item number 17. 17, Lordship.
What other side?
Lordship, I pray for 2 weeks' time, Lordship. I pray for 2 weeks' time, Lordship.
Okay.
Lordship, I have a similar prayer for item number 14 and 15. These are connected, Lordship.
Who's for the petitioner?
Lordship, I'll inform them.
2 weeks, yes.
Highly obliged, Lordship.
May I please, Lordship, I beg to mention item number 18.
Your Lordship, I am appearing for 1, 2 and 3.
You've come personally also. Where's Mr. Sheikh?
He is having some urgent matter in court number.
You're ready with the matter, no?
Yes, Your
Yes.
Lordship.
You got the file with you. You're objecting to the adjournment?
No.
You're not objecting?
No.
What would
Yes,
you
yes, yes. I have filed my affidavit.
Oh, you're not objecting to the adjournment?
Adjournment, I am objecting, Your Lordship. I have come from
No, not a
Guwahati.
question of come, but you're objecting today. The matter will be taken up, yes.
Yes, Your Lordship.
Wait, yes. There's
Obliged.
objection, there's no adjournment.
Obliged, Your Lordship.
May I please, Your Lordship? I beg
Yes.
to mention item number 8, Your Lordship. I'm praying for 1 week's time, Your Lordship.
8?
8, my lord, last occasion also, my lord, this matter was adjourned, my lord.
Sir, it's not keeping well, Your Lordship.
It's little difficult, my lord. Every time matter is fixed, again we have to go through the entire file. my lord.
Yesterday he was hale and hearty,
He's having sore throat, Your Lordship.
but 1 week, then what to do? Due to the, on account of illness of the counsel for respondent number?
Respondent number 2.
Number 2. Yes.
Obliged.
Wait, please, Your Lordship. My Lord, I beg to mention item number 11. I'm praying for just 1 week, my Lord. A small issue is involved here, my Lord. My learned friend has filed the appeal for the state.
It's our appeal, my lord.
1 week, yes. You're
Okay.
there, Mr.
Yes.
No
Obliged.
objection. Yes. Yes.
I'd like to make a mention for item 12, Lordship.
Your objection to the
No,
matter.
yeah, no objection, Lordship.
Why?
Praying for 2 weeks' time.
Why 2 weeks' time? Take 4 weeks.
2 weeks,
Let's list the matter after 4 weeks on the request of Mrs. Naitang. No urgency.
2 weeks, Lordship.
4 weeks. So you would not trouble yourself again after 2 weeks of sick time. Okay, yes.
We have
Yes.
Lordship.
Much obliged, Lordship.
Supplementary list, item number 1.
May I please, Your Lordship.
Yeah.
My Lord, I am praying for an ex parte.
Where's the...
We have served a copy to special counsel's office. They were requesting us to go and serve it to the KHATC directly, my Lord. So, but because of the positive, we could not serve. But anyway, my Lord, if
He's there.
Yes, I'm here, Your Lordship.
okay, my Lord, yes.
Okay, yes.
Yes. So, my Lord, here I am praying for a stay of the impugned notice, my Lord, whereby impugned notice issued by the CM of Maharam, my Lord, whereby calling for a referendum, my Lord. Now, why I am saying this, my Lord, little brief facts that will... I was appointed, my Lord, as a Mintri, my Lord. I was appointed as a Mintri in the year 2001, my Lord. In the year 2001, and a proper sanad was also given to me. Now, as per the power envisaged, I have formed a Dorbar, and an executive committee was formed, my Lord. This executive committee was approved by the CE, my Lord, and for a period of 3 years. Now, on the expiry, the first executive committee was approved in the year 2020, my Lord, 2020.
When
Now-
you elected?
I was before that there was no issue. So those executive keeps on coming, and 2020, the issue here comes from 2020, my Lord. So 2020 likewise, I have there was a Dorbar form, and accordingly the executive committees were elected by the people, my lord. This was approved 17 August 2020 by the CE, my lord. And this executive committee was approved for a period of 3 years, my lord. On the expiry of the third year, my lord, in the year 2023, my lord, a new executive was formed. Some of them were replaced, some remains the old one. This was also approved by the CEM, my lord. This also approved by the CEM. Now, my lord, I get a notice out of blue, my lord. In the notice, they say that there was a complaint against the Mintri saying that the action of the Mintri, against the action of the Mintri. Now, my lord, as a Mintri, so many actions will be taken. They have never said, my lord, whether the action was illegal, where action was...
What action?
That is not known to me also, my lord. What action? Now, whether that action was illegal, whether that action was against the terms and conditions of the Sanat issued to me, nothing was known to me. So directly the Mintri asked me to file a show cause. The CEM directs me to file a show cause, my lord, fixing a particular date. I file my show cause. I filed this show cause also, my lord, somewhere like just to justify, my lord, how, because somewhere I came to know that...
No, but you've given notice.
Show cause.
I mean, show cause, right?
Yeah, show cause. I filed my show cause. Then, my lord, the Mintri said that there will be a referendum held in the month of, on March, 14th of March, 2024. Then we wrote a letter to the Deputy Commissioner, to the Superintendent, to the Executive Committee, to KHDC also, requesting to postpone. But the referendum was conducted on 14th of March, my lord.
It was conducted.
Was conducted, my
What
lord.
happened?
Then in that referendum, my lord, the majority of the villagers, they say that they've shown trust on me. Now what happened
Is there in the writ petition?
Yes, my lord, it is there.
Then?
So what happened is that then when the CEM saw and his ministries, the CEM and his executive Dorbar saw that I still garner the support of the villagers, abruptly they stopped. And they said, no, we'll conduct on the next date. Abruptly they stopped.
No, you said the referendum was over.
Yes.
The referendum was conducted. In the referendum, a majority was shown to me.
You,
they did not draw. Yes.
Then what happened?
They did not. The CM did not draw the conclusion. They stopped the referendum abruptly.
Because you had more support.
I had the support, my lord.
Then what happened?
Then after that, my lord, I came to know that he wanted to conduct a referendum again. So 20 villagers wrote a letter to him. Please do not conduct any more referendum. Then now, my lord, please do not conduct any more referendum because we support our Mintri. Then now on 17, my lord, that is the impugned.
No, but then if you have no fear, why are you scared of a referendum?
My lord,
if the authorities all support you.
My lord, the issue here is, my lord, the support, yes, I garner the support, my lord. The issue is, but my lord, number one thing, my lord, first of all, what kind of was filed against
Forget
me?
about the complaint.
Yes.
Complaint was made. You were allowed to show cause.
Yes.
You replied to the CM.
I replied to the CM.
You were satisfied.
Not satisfied. Referendum was conducted.
Referendum was conducted. You say you succeeded, but then there was no conclusion.
No conclusion.
And so new referendum. So what's the problem?
So my lord, now the problem is like this, my lord. If the referendum is conducted, my lord, the villagers, the main fear here is, my lord, two grounds. One is, my lord, as it is, there is no provisions for conducting a referendum against the Mintri. I can be removed if I violate the terms and conditions, my lord, by giving me a show cause, my lord. Second, that is one thing, that is a violation. By issuance of referendum again, that is a violation of the Maharam Simship Act itself.
Where does it say that? Maharam Simship Act with regard to electors? Right. If I'm not mistaken.
My lord, referendum talks about...
Yes. Page?
My lord, election and confirmation of page 260. Page 260.
260?
260, my lord.
260?
260, second part, my lord. The second part. Not the first part, the second part. 257 is the notification. My lord.
Okay, yes. 257,
right. Section 8. Section 8 is election and confirmation of Lingdo and Mintris and the essential qualifications thereof.
Yes.
So,
Where
my
does it
lord,
say?
now
Where do you say? Where do you say that it doesn't it provides for removal? Where is that?
para 3, my lord. Section 3 talks about
Referendum.
any vacancy. That's the election, my lord. That's the election.
What is this EM, deputy CM, acting CM? What about
No, any
headman?
vacancy in the post of ministries. My lord has got
Section 3.
subsection 3. Sorry, subsection 3, section 8, subsection 3, page 261.
Okay. Yes.
So it says that any vacancy in the post of ministries
This is
shall
regarding
be.
election.
Yes, this is an election,
And
my
this is
lord.
regarding election dispute.
Yes, and then election dispute. There is no
Yes.
dispute to my election, my lord. An
Yes.
appeal, then this comes appeal. The ministry shall be the next subsection 6. It talks
No,
about the head.
This act deals with election and
Yes.
confirmation of
Yes,
CM,
yes.
acting CM,
So-
doing documentaries and all.
Yes. So now this
So
act
this-
nowhere says
So this
that
act does not deal with that part.
exactly, my lord. So my point is that, my lord, when this act is silent
No,
about
this act doesn't deal with the other, contingencies. It deals only
other
with
contingencies.
manner
Now, my lord,
of-
in
manner
that
of election and confirmation of.
yes. So in that
I don't
event,
understand, why are you scared of facing referendum?
no, my lord, referendum. I'm not scared, my lord, referendum, because, my lord,
Then why didn't you go to district council? When was the notice given for referendum?
the referendum was given on the 17th July, my lord.
Then why didn't you go to district council?
My lord, district council earlier also we have approached.
No. You can't come straight here. You have a ladder of appeal where they can conduct an inquiry. Also, 17th of July.
17th of July, my
Well,
lord. Yes,
see that. Yes, let's see the materials.
the notice, my lord, 17th of July. Oh, 50. I'm sorry, 15th of July, my lord.
Where is
Page
that?
60. Page 60, my lord. Page 60, annexure 10.
60. This 15/7.
15/7, my lord. Yes, 15/7.
What reason they give for the earlier referendum? Okay, the allegation is that you constituted executive darbar without even the darbar pullen being called. See, and then
Yes.
show cause issued to you on 2/24, received the show cause, and issued that so.
Yes, ma'am. My lord, that is.
And then both of you were called there, and both of you agreed to referendum.
My lord, this is somewhere like putting a word.
See, tentang jual Persya Menteri baru Arliang like menjur berdarban peniat Menteri BQ harus ia larayan perlong sunso.
This is a word put to my mouth, my lord. We have never agreed.
Why didn't you go for the District Council?
My lord, district council, as I said, my lord,
At this
earlier.
stage, if we go by materials of the court, Mr. Yubin,
My lord.
you see you enjoy the confidence of your
Yes.
villagers.
Yes.
Then as per what is reflected here is that the complaint against you is that you constitute a proper darbar of the village,
Yes.
keeping your own people, whatever, and darbar. So that is a serious allegation.
My
and
lord.
you asked to show cause and you could not satisfy. As a referendum was called, which you agreed to, and then now it could not be concluded. And so they're going to send people to oversee. We'll send someone to the council to oversee referendum.
My lord.
Yes, your lordship.
Why don't we stop it?
Yes, my lord.
It's a democratic process.
My lord, we do not agree to the CM conducting the referendum by himself. If an observer from district council and an officer comes from a district council with a
It's
fair
tomorrow.
manner, it's tomorrow, my lord.
Where do you come so late?
My lord, it can be postponed for another week, my lord.
No, I'll disrupt everything because see, who can take part darbar? Males above 18 with
Yes,
the
ma'am.
epic cards to verify that
Yes.
that they are residents of that village. Those who do not have epic cards, but they can. Those who do not have epic cards will not be able to
Yes.
vote, even though they might be residents of the village.
Yes,
It's
my
very
lord.
fair. So,
There are, my lord, there are 180
so
male.
you're apprehensive that you'll be ousted from the post of Ministry
My lord.
once the referendum is held tomorrow.
my lord, we want a fair.
It's fair. What? See, everything's transparent. It's not a question of behind your back that this referendum been called. The earlier was called since March.
My lord.
Also concluded. You agreed in the meeting before this aim that yes, we'll.
No, my lord, that agreement, my lord, it's just a word put to my mouth, my lord. That is a disputed facts, my lord, which is.
Then how will this court look to that?
My lord, all that we pray today, my lord, let it be still. Let the district council conduct the referendum by themselves, my
You
lord.
challenge it after a referendum goes, then you go for the council.
My lord,
should have gone for the council in the first place. Why you come here at the last moment?
My lord, there will be a law and order problem. That is the most fear, my lord.
Where you said that?
My lord.
We said the petition there will be no order problem.
My lord.
Where we made that observation? See,
Off the cuff.
Mr. Euban,
My lord.
floor test
My
is
lord.
the best test. Even
Yes.
Supreme Court, when it comes to floor test, you read SR Bomai case.
Yes, my lord.
If whatever it is, whenever it comes with this every tussle, a floor test is the to prove majority is the best way.
My lord. My lord, but that the person who conducts the floor test must be also fair, my lord. Here they're going to do a
No,
ballot
see what's
test, my
in
lord.
there. They will vote by secret ballot.
My lord.
That box will be sealed
My lord.
with a red seal. It'll be taken, then it'll be counted. So, it's not a question of hand vote or voice vote. Where you said law and order problem?
My lord,
Where we stated
this
that.
I have not stated here, but I have the instruction, my lord, to that effect, my lord.
Oh, that means you'll create law and order problem tomorrow.
No, my lord, it's, no, my lord, it's not like that. But because of village,
So
because
that's your second.
Kindly-
If relief not granted by the court, then we'll create law and order situation.
no, my lord. My senior is very happy. My lord, kindly, page 58, my lord. This is what's been written, my lord.
Yes.
Page
You
58,
have
my
not
lord.
made out a case. Mr. Euban,
Paragraph 2, my lord.
You not made out a case for.
For a moment, my lord. Page 58, paragraph 2, my lord.
Yeah.
That thereafter the organization, my lord has gone.
Yeah.
That thereafter the organization of the Durbar referendum from your office on 1403 in the presence of the magistrate and the police. The villagers were supporting the headman and that he will remain as a Mintrish Nong, and the Durbar concluded the meeting without any proper decision despite the villagers supported the Mintri.
Very good. Then we'll ask.
Therefore-
we'll ask the district council to send a responsible officer tomorrow. You
Th-
do
therefore-
that, Mr. Kinta. You send two officers to where's the referendum being held?
My lord, this is in the village of Nongbri, Nongdom, my
No,
lord.
where
Nongbri,
exactly is it?
It's southwest Kasil.
How far from Mokorwa?
It's not very far, my lord.
Walking distance or by car?
By car, my lord. My lord was saying this. Where we have stated there will be a peace, tranquility, my lord. The paragraph. Therefore, we request your kind authority kindly cancel the Dorbash now.
This is an April letter.
Yes, my lord. This is April letter, my lord.
You send two observers tomorrow.
Observers, my
We'll
lord.
not.
Okay.
We'll not
Okay,
obstruct
Lordship.
grassroots
My lord,
democracy
yes.
situation. Yes.
Two observers, my
By order of the court, you can't continue.
My
And
lord.
say that.
My lord,
and-
my lord, I am deeply obliged, my lord, to observe a fair person
they'll
who
be
will
there,
do,
yes.
my lord. That is all we wanted, my lord, a fair referendum, my lord.
Yes. Take down.
Your Lordship, I'd just like to point it out
Yes.
that we don't even have any records of the writ petition. Nothing has been served upon us.
They say
But,
they served at the office.
No. I have confirmed from the office. They said they have not received anything.
Okay, you serve
We-
it now.
We'll
You send your
serve it today
junior,
itself, my
and
lord.
we'll pass orders.
My lord, today.
Your Lordship, let the writ petitioner write the letter to the secretary along with the copy of the writ petition
My lord.
on the observation of the court
We'll
today.
pass orders. Yes.
My lord, obliged,
Much obliged.
Let two observers go.
my lord, obliged.
Daily list item number 1.
May it please your lordship.
Yes.
Lordship, in compliance to the order dated 8 June,
Yes.
in compliance to the order dated 8 June 2024, Lordship, the administrative branch of Assam Rifles has informed the petitioner as regard to the conducting of review medical examination,
It's
Lordship.
been done.
Please, Your Lordship, in fact, as per my information, the review medical examination was conducted and the petitioner was declared fit.
Then you let the report be produced.
Yes, Lordship.
Yes, It's been completed, right?
Yes.
Yes, the counsels for the party submit that the review medical examination in respect of petitioner has been completed. Stop. Ms. A. Pradhan, Vice praised that she may allow how much time to produce the report?
Lordship, 3 weeks time.
2 weeks time. There are 2 weeks time to place the report for the court. Is thereafter, yes.
Highly obliged.
Item number 2.
May it please your Lordship.
Yeah.
Lordship, I was supposed to file affidavit in opposition in this matter. I have already filed it, Lord.
Very good. 1 and 2?
5 we have filed, Your Lordship.
1 and 2?
1 and 2 remaining,
You're
Lordship.
not filing?
We have not yet filed.
Yes, Ms. A. Pradhan.
3, 4, and 5 they have filed.
4 and 5.
I received the copies.
You already filed.
Yes, Your Lordship.
3, 4, and 1 and 2 is 3 is
Ministry of Personnel, Public
UGC.
Grievances. Yes.
Please, UBC, my Lord.
4 and 5, 1 and 2? Already filed. Yes. You won't file.
And 2.
The 1 and 2, Ms. A. Pradhan, the counsel vice Dr. Mozika for 1 and 2 submits that no affidavit before coming from the said respondents as the only formal parties. Stop next paragraph. MSP Agarwal or Dr. P. Agarwal submits that affidavit behalf of respondent number 3 has been filed.
Lordship, I pray for time to file
For
a
rejoinder.
rejoinder.
Mr.
Yeah.
D.K. Datta. Next paragraph. Praise for the loud. How much time? 2 weeks time for rejoinder.
Yes.
Yes.
Item number 3.
Obliged.
May please your Lordship. Lordship, I seek some more time to file my
How many
rejoinder.
times you asked?
This will be the second time if I'm not
As
mistaken.
wait for further 2 weeks time granted for rejoinder.
Deeply obliged.
Highly obliged, Lordship.
Item number 4.
May please Lordship. As per the last order is dated, Lordship, I supposed to file the RPTP service. However, yesterday only I confirmed that from the post office they have actually the private respondent have received the notice. So I'm yet to file it because I didn't get that copy, Lordship.
4, 4 and 4?
Yes,
Respondent
that
number?
private respondent number 5, if I'm not mistaken.
No, 4 and 5 is the
Yes. This.
for number 1.
It's for number
Yes,
1,
yes.
Lordship.
Yes, Lordship. Number 1.
Petitioner,
Opila. Yes.
There's
number
allowed 1 week further time to file service affidavit indicating service of notice on respond number 1. Yeah. This is
Much
also-
obliged,
also-
Lordship.
Item number 5.
May I please, Lordship? Lordship, I'm for the petitioner, Lordship.
Yes.
Lordship, I'm for the petitioner. Lordship, on the last question they are supposed to file in affidavit, Lordship.
So I also require some more time to file my affidavit.
Why? What's the matter about? What's the matter about?
Lordship, it's a matter regarding the transfer of the petitioner, Lordship. And Lordship, the petitioner have not received the salary since November 2023, Lordship. This is very he's going through a very bad situation, Lordship. Lordship, kindly
File affidavit.
Lordship, PWD, Lordship.
Oh, which one?
Executive Engineer, Lordship.
Which division?
Lordship, Receivable Para.
It was not filed within next 2 weeks, then
Lordship,
Mr. Karana submits the appraisal allowed further 2 weeks time. He has noted that the matter concerns the transfer and non-receipt of salary of the petitioner. It is expected that on the next date after it be on board, feeling which other orders will follow.
Lordship.
Have you received instructions?
Lordship.
Then show your instructions.
There was some.
Then you file affidavit in 2 weeks. Otherwise,
Lordship, I'll make sure that affidavit is on point, Lordship.
Item number 6.
people will be deprived of salary.
Much
wrongly
obliged. November 2023, Lordship.
Yes.
Obliged.
May it please, Your Lordship, we still require some more time, Your Lordship, to file our affidavit.
I have filed my affidavit.
You filed.
For private respondent.
What's the matter about?
regarding
regarding the recruitment to the post of assistant teacher, Your Lordship.
Recruitment, fresh recruitment, or
Not fresh recruitment, my lord. Actually, the petitioner
same
is
one
paid-
regarding the test?
Yes, petitioner is the
The
paid
s-
candidate.
Oh.
He was.
How much longer?
Another 2 weeks, Your Lordship.
For the 2 weeks' time, as prayed by MS Yang 11 AAG, was upon 1 to 3 is allowed for affidavit list thereafter.
Item number 7.
Yeah, please, what, Lordship? I'm praying for 2 weeks' time to file a. I'm praying for 2 weeks' time to file affidavit.
How much time? Already lots of time been granted.
We have taken 2 times. This is the third time.
More than 2 times.
This is the kind of pension?
Yes, Lordship.
Gratuity?
Gratuity.
GCDC?
Yes, Lordship.
Then you can keep on praying, yes. For a 2 weeks' time, as prayed, granted. Yes.
Possible, Lordship.
Supplementary list, hearing item number 2.
Is there arbitration clause?
Yes, it is there, Your Lordship. I got the paper.
Yes. Let us see that.
Page.
You're not aware of this, Mr. Jindal?
Oh, Lordship, I am.
You're aware now?
Yes.
Page 86.
Yes. Yes, in the course of hearing, it is discovered that Mr. D.K. Datta submits that as there's an arbitration clause, they may want to withdraw his application and pursue alternate remedy under arbitration. This matter stands closed. There, clause 39. I know, funny. It's still within 3 years, correct?
Lordship.
After the conclusion of contract, still 3 years.
Oh, 3 years.
Then they can still go
Very much.
arbitration.
Very much.
Obliged.
Obliged.
Daily list, item number 9.
Why, Mr. Sheikh, you're taking unnecessary adjournments? Why are you taking unnecessary adjournments in the other matter?
Lordship, in fact, I was reading this matter, Lordship. Yeah, Lordship.
Yes. Where's Mr. Abraham?
Lordship, I'll be there, Your Lordship.
My Lord, on the initial days, my Lord has posted query whether the judgment passed by answering, whether any challenge has been made by the state or not. So the query, and after that, they have said that no challenge has been made. That means the judgment attained finality, Lordship.
No?
Now,
No appeal is preferred.
Yes, no appeal.
Yes.
Now on the last date, Lordship, he raised the issue saying that no, I was not given the benefit of other earlier revision of pay, Lordship. That is factually incorrect, Lordship. Why I am saying, Lordship? My Lord will find the copy of the revision of pay, Lordship.
You were released from when?
I am still, Lordship, I am yet to retire, Lordship, but I have been disengaged.
Disengaged from
December,
when?
Lordship. December last year, Lordship.
Okay. Yes. This is, what is this? 2010.
Yes, Lordship. Lordship, I put the flag, Lordship.
Yes.
Page number 20, Lordship. 19 is the district home guards and organization. Existing pay and the revised pay. That is the fourth pay commission, Lordship. The 74, Lordship, the guardsman, Lordship. The third pay revised was 29 and the fourth pay revised was start from 7700, Lordship. That will find in the counter affidavit, Lordship, filed by the state, Lordship.
Yes.
the revised pay, that is at page 12 of the counter filed by the State Lordship. When
Page 12.
page 12,
This chart.
this chart, Lordship.
Yes.
That, page 11 is the covering letter, Lordship, and page 12 is the chart.
Yes.
Now this is the benefit of this is the revision of pay as per 2010 rules, Lordship.
Yes.
Now, Lordship, I'll come to the third pay commission, Lordship. That is in my writ petition, Lordship.
Yes.
My Lord can
This
tell
as
you.
per the fourth administration.
Yes, 7/7, yes. Now third, Lordship.
Yes.
Third will find page 13, Lordship. Page 13 in my writ petition. Because in the revision of pay, Rule 2010, two pay scales are mentioned, the existing and the revised.
Page 13.
Page 13.
Yes.
May I read, Lordship?
Yes.
This is a letter June 1999. The
96.
following guardsmen are hereby allowed to raise their pay scale to rupees 2900.
Where are you reading from?
Page 13 in my writ petition,
Oh,
Lordship.
13. Sorry.
1-3.
The foreign guardsman, yes. Yes. This is from not raise a pay scale to so and so instead of
29.
so and so. So 29 is the third pay commission.
29 is the third pay.
No, but then this existing scale of pay they being paid 29. Oh yes.
That is the third pay.
Right, right,
Then
right.
what they have given in the format,
right,
Lordship,
right,
that is
right.
the fourth, Lordship. That was my existing.
Right. Yes. Correct. So that means all along they were paid
Yes,
as per the whatever revision of pay was
Yes.
there. Okay.
And that I have pleaded in my writ petition, Lordship.
Yes.
Only the fifth was denied to us. And when I filed the case, then we have been arbitrarily
Kicked out.
disengaged.
Yes. But the thing is that now, as per the revision of pay, the pay is disbursed by the requisitioning agency.
Yes,
Correct.
Yes,
Not by the what do you call it, civil defense.
Yes, Lordship. They used to prepare and they forward the
And
requisition.
grounds of your ground of appointment and engagement also, if don't require any more, you're out.
That is I have in the second writ
That you
petition.
have no quarrel.
That
So you're saying, since you, when did the recommendations of the, you paid fourth pay commission, that
Yes,
means. Till when?
till December 2016, Lordship. Because
Till
the
December
fifth pay
16.
commission came into effect 1st January 2017.
1st January
2017.
When were the recommendations accepted by the state government?
That
On
made
this-
effective from 1st January
Oh,
2017.
wait, the recommendation accepted.
Yes,
And then you disengage from?
disengaged January, December.
December.
December 2023, Lordship.
So last pay you paid till
Till December 2016, Lordship.
That's it.
Because that the revision.
And you have paid the same pay till 23.
Till 23, Lordship. Till 22, 23, Lordship.
You paid another 4th pay commission
Yes,
only. Yes.
Now my due will be 1st 2017 till I have been disengaged.
The arrears.
Yes, arrears, Lordship.
Yes. Where the judgment of Justice Ansari? Yes.
And the reason they have cited because of the Supreme Court order. But the Supreme Court order that the Gra Rakshak never denied the benefit of pay revision, Lordship. It's only denied the regularization. They have interpreted the order and saying that since the regularization has been denied by the Supreme Court, so meaning thereby that they are not entitled for the benefit of the 5th pay commission.
So even your appointment was that will be we allowed the time scale allowed to the regularly appointed home guards.
Yes.
Where is that? In your petition?
Page, Lordship, 11, Lordship. One.
Yes. Yes, Mr. Shulai.
This is Lordship. Lordship, here the question is whether the home guard volunteers are entitled to the pay commission, Your Lordship. In my humble and respectful submission, Your Lordship, my submission would be in the negative, Your Lordship. They are not entitled. Lordship, if Lordship, I take to first, Lordship, to the appointment. Lordship, I have seen it at page 11A. That is the type copy. Writ petition, that is a writ petition number 37 of 22, Your Lordship. Kindly see, Your Lordship. Lordship, so for the first part, in my humble and respectful submission, Your Lordship, this is wrong, Your Lordship. It is wrong, Your Lordship, because 11A, Your Lordship, the appointment of the writ petitioners.
Yes.
The appointment order. Kindly see, Your Lordship, below. The appointment is purely temporary and especially for the guard duty of the PHE stockyard at Mentadu and in the PHE campus. The service may be at any time on 1 month or one month's advance notice without assigning any reason thereof, Your Lordship. They are not regular. They are not regular employee or they are not in the whole time government service, Your Lordship. The stipulation
No, but you see, they are paid as per the Meghalaya
Lordship,
services.
that is very wrong. I must admit, Your Lordship, that is very wrong, Your Lordship.
Then what is wrong? Then
it's very wrong. It's wrong, Your Lordship. It's wrong, Your Lordship, because this kindly see the condition, the below, Your Lordship, the term of the appointment, Your Lordship. If they are,
you see, for guardsmen, sorry, I don't want to argue with you, but the thing is that the terms, things stems from the terms of appointment.
Lordship, I'll come later.
Engagement is from your appointment.
Lordship,
Now,
in
other
fact, Your
cases,
Lordship, Your Lordship, it is a mistake. I must admit, Your Lordship. In fact, Your Lordship, this order should not have been issued by the home card, Your Lordship, because home card is just forward only the names to the requisition department. It is the requisition department to issue the order of appointment or engagement as the case may be, Your Lordship. I admit, Your Lordship, it is wrong. It is wrong, Your Lordship. But, Your Lordship, if they are regular employee, Your Lordship, then that condition, 1 month notice, would not have been there in the appointment, Your Lordship. So this is shows, Your Lordship, that they are mere volunteers, Your Lordship.
They are volunteers.
Volunteers,
but
Your
it's
Lordship.
only with regard to their terms of engagement. If you can afford them regular pay,
Lordship, it's wrong. I must admit, Your Lordship, this is wrong, Your Lordship. But, Your Lordship,
all engagements like that. All home guards like that.
Appointment like that. Even the regular appointment also they used to make
they are not
temporary.
the whole time. Lordship, kindly see.
That was the format they were.
Kindly see, Your Lordship, at the pay commission. Whether it's applicable or not, Your Lordship. Lordship, kindly see 2I, Your Lordship. This rule shall not apply to person not in whole-time employment, Your Lordship. They are not in whole-time employment, Your Lordship.
This is notification.
Lordship, yes, this is notification. Lordship, this is a copy from the Meghalaya's services revision of pay rule 2018, Your Lordship.
What does the main rule say?
Lordship, say is
what does this say that has been produced by him? This is the
same.
See, revision of pay rule 2009, revision of pay
Even
rule
Lordship.
2010. Now you see one thing. See, Mr. Shulai.
Lordship.
If the revision of pay rules, which have incorporated the recommendations of the pay commission, they become part of the rules. Correct?
Lordship, yes.
They are rules made under
309, Your Lordship. 309
now
of the Constitution.
Your notification issued by Finance Department is just an executive instruction.
No, Your Lordship.
Yes.
No, Your Lordship. That is the rule. That is the rule, Lordship. This is the rule, Your Lordship. It says, Lordship, kindly have a look at 1980, Your Lordship, please.
Show me the book you're having.
Lordship, kindly have that first rule, 1980, Your Lordship. If Lordship permits me, let me read, Your Lordship. In exercise of the power conferred by the Proviso to Article 309 of the Constitution of India, the Governor of Meghalaya is pleased to make the following rule, namely...
You shall not apply to person not in full-time
Lordship,
employment.
this rule, Lordship, I'm coming to 2.2, Your Lordship, of the rule 1980, Your Lordship. This rule shall not apply to person not in full-time employment, Your Lordship. Shall not, Lordship. As I have submitted, Your Lordship, the first part of the order of appointment is wrong, Your Lordship. I must admit, Your Lordship, this is wrong, Your Lordship. It should not have been. It should not have been issued in this way, Your Lordship.
You see, by your own appointment order, like this court keeps on saying, at the risk of repetition, every service of every employee, the root of the service is governed by the terms of employment. Correct?
Lordship,
and
correct.
whatever right he derives in the course of his engagement or employment, you go back to the root. That is what does his appointment say? Now your appointment is made as far back as in
1986, Your Lordship.
1986.
Lordship, yes, Lordship.
86. Now what have you done? You have said that you'll pay as per the revision of pay rules, and after that, when the revision of pay came, you gave him the higher scale. Again, when the last now, you allowed him the benefits of fourth pay commission. Now after disengagement, he said no. Now he is entitled. He said he has not. Then they have come forward that since all along, from the time of engagement 86, I've been afforded whatever revision of pay has been there for regular employees. They've been given that.
Lordship,
so
I admit,
by your conduct itself, all along these years you've given them. Now last part, can you retract now and say that?
The only thing, Your Lordship, in the condition itself, in the order of appointment, Your Lordship, that condition is there.
That doesn't matter. We can't
one more notice, Your Lordship. If we are to disengage them, if the recruitment department,
they have no quarrel with that. Disengagement, even tomorrow, suppose the department says we don't want you, they're out. But before they were out, what are they entitled to? What were the conditions that you give them?
Lordship, my humble and respectful submission, Your Lordship.
You're right.
View of because the rule, the pay revision rule is very clear, Your Lordship. There is clarity,
You
Your
can't take
Lordship.
shelter of the rules now.
They are not in full-time employment of the state, Your Lordship.
We're not going to exactly, because it will not apply to contractual
employees. Lordship is absolutely
by the
right,
appointment
Your Lordship.
by the appointment order, they have been.
But
they might not be in the revision period, but they've been given that benefit.
It is a mistake. If Lordship permit, if I may please one judgment passed by this Honorable High Court, Your Lordship.
So what are you going to do? You're going to correct this order now, retract it, 86.
Lordship, subsequently, Your Lordship, what happened, Your Lordship, then government maybe after seeing all this, Your Lordship, then they have come out with a notification. If Lordship permits me, I'll bring all those by an additional affidavit. They have given lump sum payment, Your Lordship.
See, you should have got assistance right when the matter had started. Sorry to say the assistance was very bad. We could not. So that's as simple as that. Now, Mr. Sheikh has shown all along during first appointment.
Lordship, yes, that is why I admit from the very first submission, Your Lordship, I admit, Your Lordship, that the order of appointment is wrong. You know.
Even your
It's
notification
wrong,
will
Your
not,
Lordship. I
will
admit,
not
Your
apply.
Lordship. I must be fair, Your
We
Lordship.
accept notification.
I must be
but
fair,
then
Your
they
Lordship.
have carved out exception for them.
I must
you
be
have
fair,
carved
Your
out exception
Lordship.
for them.
Because
By
but the
appointing-
second part of the appointment, Your Lordship.
Is inconsequential. But the first part, which is substantial, you yourself have given the benefit.
Lordship, yes. As I have admitted, Your Lordship, it is
My
wrong.
lord,
It is
what,
wrong. You should-
what my learned senior is saying that they have corrected the mistake in
Then
in the
later on,
18.
Your Lordship.
That
You
revision
file
of
a bring
pay
out
rule
report.
2010 and 18
We'll
is the
address
copy
it.
and
We'll
paste,
address-
Lordship.
we'll
Copy and
address it.
paste.
No, he understands. Mr.
Copy and
Shukla
paste.
understands very well. You filed a petition affidavit.
Lordship,
As Mr. Andy Shurai has just been engaged to argue the matter on behalf of the respondents, and certain issues have cropped up which need further clarification. He pleads for and allowed 1 week's time or 2 weeks' time?
Let be 2 weeks.
2 weeks' time to file.
Lordship.
Simple as that. Open and shut case, nothing here in the
Lordship,
matter.
yes. It is a mistake, Your Lordship. It was a the biggest mistake, Your Lordship. Of
They're
like, Your
reaping the benefits, no? You
Item-
paid them on a fixed pay, nothing, whatever is it.
But Lordship, so far the disengagement, Your Lordship, the term of the appointment is very clear.
They cannot even open their mouth on that point.
Lordship.
It's only on the entitlement.
Then now I am only on entitlement. That will I'll
Yes.
Item 13.
What understand?
Yes.
Yes. Mr. I'll not take out this. We'll not take out this matter anymore. You better withdraw it. Because it's splashed all over the papers. This petitioner is seeking alternate remedy before the media. I think we'll have him. This is a very serious matter. Mr. Mahanta, you've seen what happened.
I have seen that.
And then it's written in the paper that the matter has been listed for 20 times and has not been heard.
It's a very unfortunate, in fact.
Have you seen the orders on why it wasn't heard? Has the court ever refused to hear this matter?
No. It's very bad.
Lordship, I was about to bring this to the
We
notice
will
of this
take
honourable
judicial
court.
notice of this.
There was a press conference and everything is
Yes,
there on
you take
social
down.
media.
The petition and instant petition, as it appears from media reports, you collect that and please supply it to the court.
Lordship.
Has
Without our knowledge, you will
has
not
spoken
see-
to the media with regard to the pending matter, and certain statements have been made which will be considered further by this court. Copies of the learned government advocate to supply copies of the media transcripts and
Lordship.
cuttings before next year.
Very
Can you
unfortunate.
do this? See, Mr. Sangma, if
we will do
the matter, we would have heard it in the first day.
Yeah.
For some reason, others always adjourn.
Yeah, that is.
And then you say that 20 times it's been listed in.
That should not happen. That's
We're going to take very strict action. Maybe we'll take sumoto contempt against him.
Lordship.
Yes.
Item 16.
Much obliged, Lordship.
Yes. But maybe. Was this matter heard in part? No.
No. First time.
First time.
Yes, Your Lordship.
No, this is a.
Both sides
revision.
ready? Ready, Mr. Khan?
Yes.
Very good.
No, this is a revision. Against the order dated 24 July 2023, my lord, passed by the lower court, my lord, in respect to a probate
24
case.
July 23.
23, my lord.
Yes.
My lord, the brief fact is that the respondent herein has filed a probate case in respect of a will.
That means Mr. Sangham's client.
Well,
Yes.
on the basis, after the will was filed, my lord, notice was issued to the petitioners here. We are around 7 of us, my lord. Brothers and sisters, my lord. Will was executed by the mother, my lord.
You mean the fight in brothers and sisters now? You didn't go for mediation?
It didn't go to mediation, my lord.
Mr. Sanghan?
Will has been.
The wills favored only you.
No, in his clients, to the respondent, my lord.
Okay, let's continue.
So, my lord, what had happened is that after the after the probate was filed, so we had notice was issued to us. We had filed the show cause against the will, whereby we have raised objection.
Now, just 1 second before you proceed. That means how? Do you have and others? Meaning how many petitioners are here?
7, my lord. 8 brothers and sisters.
7.
My lord.
And this the respondent.
The respondent is one of the sister, my lord.
She's the youngest.
No, the respondent number 7 is the youngest, my lord.
And this sole respondent is?
Sole respondent is number 2 or number 3, my lord.
That means all of you,
1,
the
2, 7.
petitioners and the respondent, brothers and sisters.
Yes, my lord.
Okay. Very sad. Yes.
My lord, what had happened is that the land which has been willed to the sole respondent,
yes,
that land has already been sold to the youngest daughter, who is the respondent, the petitioner number 7, my lord, in this case, right? By the mother herself, my lord.
Sold?
My lord, by way of sale deed was executed. And the respondent, the sole respondent, also has given an NOC in that to that effect, my lord. That was done in way back in 2006 and 2007, my lord. And the will was executed only in 2017, my lord.
Now you see the seal was done on
2006 and 2007, my lord.
Sale of the property.
Of
the
the
will
property,
only
my
respect the property.
My lord.
Can we go to the will? Let's see it.
Yes, sir. Page 75, annexure 2, my lord.
Yes. No, she says. Where? Okay. Jacinta. Is the registered will?
No, my lord.
Notarized.
Notarized, my lord.
Now, time of granting probate, what these witnesses examine?
No, my lord. We had filed we filed a show cause. Then the issues were filed. Then, on the basis of the issues framed by the court, we had filed an application for preliminary hearing on the manual.
It's not been probated as yet.
No.
The will. Okay. I thought
we
that
we have raised a question of law that, as if your lordship see that at page 80, executor has been appointed. One executor has been appointed, my lord.
Yes.
By the name of Archangelo Sindor.
Yes.
So, my lord, we had raised an objection before the trial court, saying that the will could not have been probated, or the application probate could not have been filed by the respondent by virtue of yes, 222, my lord, which clearly provides, my lord. So that is our ground. That was the ground taken by us in our show cause. And
who's in possession of the land?
Well, we are in possession, my lord.
Both of you.
Well, we had filed a suit also in this regard. Injunction has been also given to us, my lord.
Okay, I will reply later. Section?
222, my lord. A very limited point of law, my lord.
Excuse me.
Probate only to appointed executor, my lord. 1. Probate shall be granted only to an executor appointed by the will. The appointment may be express or by necessary appointment. My lord, in this case, the will has categorically expressed that Shri. If my lord comes to page 80, my lord.
80.
80, my lord.
I've seen that, yes.
Archangelo Sindor is the executor, my lord. So, my lord, in the show cause filed by us, we have raised this issue. So, on the issues which has been framed by the court, my lord will kindly come to page 7, paragraph 6. The petitioner herein states that both the parties herein had then filed the suggested issues, but order dated so-and-so, the lower court below was pleased to frame 13 issues. On the basis of the issues framed by the lower court below, the applicants had then challenged the maintainability of the probate petition by their application, which was registered as petition number 192/23, dated so-and-so for primary hearing on issue number 12789 and 11, my lord. So these are the issues, my lord. 6 issues, which is 1, 2, 7, 8, 9, and 11, my lord.
Okay, first one is 1, whether impenetrable in
My
law.
lord.
Then with any cause of action.
My lord.
The
Whether
7 is
whether the will dated so-and-so is executed as per provision of law.
whether the
will dated 1/9/2017 is executed as per law. Whether the instant.
No, where's 7?
My lord, I have 1,
Okay.
2, 7, 8. My lord, I have just.
These ones.
These are the these are the
okay.
6.
Whether it's
issues.
applicable as state partner had already sold both of plot of land. See, this one thing, there's twofold. First, you say that if any will should be filed by executor,
Yes,
and
my
out
lord.
here you say that land has already been sold.
Yes, my lord.
Okay. Right.
So these are the 6 issues which was challenged by the applicant, my lord, before the trial court for hearing, my lord.
So what
On the
happened?
basis of this, my lord, the impugn order has been passed. If your lordship see the at page 8, my lord, paragraph 7, my lord. This is the finding of the trial court, my lord.
You kindly read.
My lord. That the petitioner here states that the respondent on receiving of the copy of the petition number so-and-so, dated so-and-so, had accordingly filed the show cause on 15/7/2022. Both parties then had, by way of written submission, filed their respective argument to the petition number 192/23, dated 28 March 2022. While order dated 24 July 2023, the lower court was pleased to dismiss the petition number so-and-so, dated so-and-so, as follows. On having perused the written submission of the learned counsel for both parties and upon proper perusal of the instant application, its show cause along with the material available on record, it is found that the objector have challenged the maintainability of the will dated so-and-so in respect of the landed property mentioned in the said will, as the objector are contended that the suit properties has already been sold by the deceased mother of the petitioner, by sale date so-and-so and dated so-and-so. The objector are also contended that the will alleged to be executed by late Quintina Nungri is false and manufacture, as late Quintina Nungri is an illiterate woman who cannot read or write. It is further contended that the deceased testatrix has appointed an executor to the will dated so-and-so, namely Sri Arch Angelo Sindor, who would execute the will, and the petitioner, being only a beneficiary of the will, has no right to file the instant petition. On having perused the application for preliminary hearing on issue number 1, 2, 7, 8, 9, and 11, it is found that the issue sought for having involved only issue of fact. Under the provision of Order 14 Rule 1, Sub Rule 2, Clause A and B provides that whereas issues both of law and fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of an issue of law only, it may try the issue relates to A, the jurisdiction of the court, or B, a bar to the suit by any law for the time being in force, or for the purpose may it thinks fit postpone the settlement of the other issues until after that issue has been determined, and may deal with the suit in accordance with decision on that issue. Based on the above provision of law, I hereby convince that issue prayed for by the objector does not involve issue of law which requires to be disposed of at the preliminary hearing. However, the issue that has been prayed for at this preliminary hearing requires to be determined through evidence. Furthermore, as the question raised by the objector that the petitioner being the only beneficiary of the will has no right to apply for probate. In this issue, I am of the opinion that the purported will dated so and so, that the statistics have expressly named the petitioner in the said will. Hence, the petitioner and the said Arch Angelo Sundar may be admitted to apply for probate. Based on the above findings and observation, I am hereby convinced that the preliminary issue numbers 1, 2, 7, 8, 9 and 11 shall be decided through evidence, my lord.
Okay.
So this is the finding, my lord. That's why we are before this honorable court, my lord.
See, one thing, Mr. Kiran, but it's on two issues you have come. First is not a preliminary issue in a question of law also for the trial court. The first issue of law is that whether the probate could have been filed by the respondent. Second one is that this has already been sold.
Yes, my lord.
That requires.
That's the ground which I have taken. But my, the
no,
main.
But the thing is that whether probate is granted, that will be the main ground, you know. Like, barring the question of law.
My lord.
Now, because it is twofold. It's not only that. Not only that. Ms. Singon's client, respondent, has come and filed the property is not been built. I mean, it's not been sold. It's still intact. Then that preliminary issue will have to be decided whether he was competent to file for probate. Correct.
Yes,
but then if that's already been sold, then how will the trial court?
No, my lord,
that we have segregated the issue then.
No, the grounds we have taken is separately, my lord.
No, whatever it is, but then in preliminary issue you ask for both. You've asked for the issues to be considered, right?
My lord. But my lord, the trial court should have addressed the issue which has been raised by us in as far as the maintainability or the locus of the respondent to file for probate, my lord. Because section 222 clearly provides that if there is...
Just see any authority you brought?
My lord. They're very old authorities.
But the only thing that is because of this your second objection.
My lord.
That the property is not available to be willed anymore.
Yes, my lord.
Well, first you said the sale deed was on
2006 and 2007, my lord.
2006 is right. Okay, 2006, 2007.
Will was executed in 2017.
Yes. Yes.
My lord, paragraph 3, 4 and 5, AR 1917, Patna 209, my lord. It is quite clear on the authorities that it is not the business of the court receiving an application for probate to hold an inquiry as to the property of the deceased or to be considered any issue as to the title of the testator or his power to dispose of the property which the will purports to deal with. So far, therefore, as the first reason is concerned, I am of the opinion that the district judge was wrong in refusing to grant probate. The second reason for refusing to grant probate to the appellant is that he is not the he was not appointed an executor by the will. I have already stated that the will expressly appoints 6 persons to be executor. This, of course, is not conclusive against the appellant for an executor according to the testator, to the tenor, as he is called in the Indian Act. An executor by necessary implication may be joined with an executor or executors expressly nominated. But the will does not impose upon the appellant any of the ordinary duties of an executor. It does not direct him to pay the debts or get in the assets. It merely leaves practically the bulk of the testator property to him. It is true that the appellant is directed to pay a number of annuities out of the income which it was supposed he would receive from judgments, but that duty is not imposed upon him as an executor, but it imposed upon him.
What is the purport of? I mean, this law is very old.
My lord.
If the person's name the will itself,
my lord.
The person, I mean, the beneficiary.
My lord.
Now, does that preclude if the name and the will that precludes them also?
Yes, my lord. Unless if the executor, if no executor has been appointed by the testatrix, then implied that the beneficiary, she is just a beneficiary, my lord. So that is my case, my lord. Since the executor has been expressly named in the will, so
yes.
He is the only person who will be eligible to apply for a probate.
Because what this judgment is correct also, Probate court does not decide title.
My lord.
It's just to see whether the will has been properly executed and is brought for, and only thing to see the veracity of the will. That's all.
Yes, madam.
That's the duty of probate court.
Yes, madam.
Yes.
But there one more citation is this 2018.
This is too old. This is
2018 SCC.
before, during First World War time. This
Yes, madam.
for judgment.
Very rarely.
All testimony matters. You won't get the earliest one. You get me 50s. Yes. Any
Paragraph 140. Para 140, madam.
140.
Yes, madam.
114.
140, madam.
Penipshan it, yeah.
However, under Section 222 of Indian Section Act 1925, the probate shall be granted only to the executor appointed by the will. The appointment may be expressed or by necessary implication. Mr. Shah, learned counsel for the respondent number 1, could not point out any such provision in any alleged will appointing her client ex-executrix under the said alleged will. In my view, if the respondent number 1 would have served citations upon the petitioner could have raised all such objections in the disseminatory petition number so and so at the relevant time. In my view, since the respondent number 1 was not appointed as the executrix under the said alleged will left by the father of the petitioner, this court could not have granted probate in favor of the respondent number 1 in view of the clear mandate of Section 222 of the Indian Section Act 1925 to grant probate in favor of the executrix appointed under the will.
Is it a finding or is it a submission?
It's a finding, madam. Grant of probate in favor of the respondent number 1 deserves to be revoked on this ground alone. The respondent number 1 does not fall within the definition of executor under Section 21C of the Indian Succession Act. So, well, my contention is that if at all anyone who is eligible to file for probate in this particular case would be the executor who has been named in the will, my lord, not the respondent in this case, my lord. The law itself, in my respectful submission, my lord, bars the respondent from filing the probate case, my lord. Probate miscase.
Then, Mr. Korean, we should have just asked pointedly on this point of law.
That also of law has been
but
raised.
then the thing is that they have received the trial court, the probate court has said, because it's a mixed question law, in fact.
No, but we have raised why, because we have challenged in the issues which has been raised by us, we have raised all these issues in our show cause and the issues which has been raised by us also, madam. On the basis of that, all these issues has been framed by the court, madam. That's why we have challenged the maintainability as well as the challenge on whether the testatrix would have the power to execute the will by virtue of the sale deed which has
So that does different. That cannot be taken as primary issue. That has to be taken.
Those
that
issues
has to be taken.
by way
Has
of
to be
evidence.
taken in the main, because that is the most substantial objection you have to the capacity of the
testatrix.
Yes, to execute the will. Yes. That's the only thing. Yes, Mr. Khan, what do you have to say?
May please, my lord. My lord, actually, to my little understanding, my lord, there is no perversity in the order passed by the London Court below. You know, actually, the contention is that at one point in their own reply and show cause, they have said that this will is a fabricated document. And on the other hand, they said that no, the will should have been probated by the executor. It means the will is genuine and executor is there. So because of that reason, you know, in order to determine that point, the London Court below has framed that issue also. At issue number at issue number 12, my lord, pH 239.
Of the
239. Issue number 12, my lord, whether late Quintina Nombri in her purported will dated so and so had appointed one Sri Archangelo Sindor as the executor. So the Learned Trial Court below, Your Honor, wanted to then this issue to be determined by way of evidence. Now the question is why this Sri Angelos Sindor is not
present.
Yes, he's not present. He's not filing. That is the question of fact, Your Honor. What prevented him to come forward? What prevented the executor to come forward? That is it's a question of fact. It's not a question of law, Your Honor.
This matter is pending since 22.
My lord.
And my lord, the only duty of the probate court, the primary duty of the probate court is to determine the validity and legality of the will. That is the main thing. And the probate court will not touch into the the question of ownership or this and that. Regarding their contention that the land has been sold, they have filed 2 title suits, Your Honor. 2 separate title suits, and in respect of 2 lands, and that is still sub judice before the trial court.
What stage are they?
In respect, because in this will, Your Honor, 2 lands have been mentioned.
No, those other suits, what stage are they?
Issues, Your Honor.
Issues have to be framed.
And their content, they have mentioned that they have got restraining order. Actually, they got that restraining order, but finally, that case has been disposed of, and the Leonard Trial Court below has directed both the parties to maintain status quo in respect of those 2 plots of land.
What did you file for probate?
You know?
If the suits are pending, the probate came before,
we
or the
filed,
suit came before?
We filed first probate, and then they filed the title suit. So I think the issues framed by the court is involved only a question of facts, and because of that, the court has rightly given both the parties the opportunities to lead evidence of the order, Your Honor.
Yes. Any judgments?
You know, actually,
well, the only thing, it's a probate court decide only the validity of the.
This is the relevant judgment, my lord. If you come at page number 11, para 22. Para 22, my lord. In this context,
Yes.
para 22, my lord. In this context, when the scope of jurisdiction of the court, considering the questions of probate of will or grant of letter.
This is a settled position of law.
Yes.
That's what it is.
So the probate court will only decide the validity of the will and the issues involved, which my.
No, but one thing, Mr. Kriam, but then the issue regarding the title suit is still pending also. What are the numbers of title suit?
Title suit number 20 and 23, my lord.
Yes, kindly. It's by 7 of them against 1 of you. It's same.
No. Filed by the respondent number, by the petitioner number 7. She is the only.
Which DS is this?
What?
Title suit number?
Title suit number 20 of 2019. That is in respect of the plot A mentioned in the will, and title suit number 23 of 2019 in respect of the land plot B mentioned in the will.
Filed by number 7.
Filed by number 7.
The youngest daughter.
Yes, yes. Because sale deed is already in her name.
Okay. For declaration.
Well,
yes. We will pass orders.
Obliged.
We will reserve it.
Well, that's the only low point which I've raised, is that because
the thing is that yes, Mr. The thing is that because yours is it's mixed up with other things, so it's a bit difficult for
but my lord,
to completely clear finding reject the at this stage.
The only thing is that
the issue has been framed that whether even the let him decide and then let her decide all this at this point first. We'll direct that she decided. The probate matter then just set it together with the other attendant facts. Yes.
Much obliged.
Yes.
See, I sought little accommodation.
She's come all the way from.
Yes, Lordship, true.
in the wind and rain. So you give your sister some
Yesterday I was out
consideration.
of station. I reached late yesterday, Lordship. So I prepared that other two matters. I thought that this matter at the bottom of the list, I'll ask time.
What are the two matters?
Item number 9 and 10, Lordship.
Who's the paying for the Deputy Commissioner with Hasiels? You file affidavit on his behalf?
File, Lordship.
So what
Here
to
one
do?
technical issue might arise again, Lordship. Because as per their affidavit, they are saying that the payment has been made to the NOCMA, Lordship. What I feel to the NOCMA, because they are saying that this is the Aking land.
Was been paid to Nokma, then it's over for you then.
It is not.
Who
they
are
have,
you?
It is not. They have said that they have paid, but here are two components, Lordship. One is for land, another is for tree, Lordship.
What?
One is for land, and another is for tree.
So that's all part of composition. Land, tree, structures is part of one.
No, Lordship. My submission is that cannot be, Lordship. Suppose this is a land, Lordship. Now they are saying that this is not my land, but I have been occupying. Till now, I have been occupying. There is a dispute. Since I raise, I'll I try to satisfy the Lordship.
Yes.
If Lordship feels, then I'll take necessary step on the date of hearing.
Yes, sir. Lordship, he could have informed earlier also.
Yes, yes. Okay, you
Just-
pay
just-
her
I'll
for
take
her
her
lunch
number.
and for transport.
I'll take her number, Lordship.
Yes. As the arguing counsel expressed difficulty, expressed personal difficulty. This is matter on.
After 2 weeks, Lordship.
Take a date. Yes, 2 weeks. Yes.
Obliged, Lordship.
I'll inform you in the
You
event.
serve copy.
Pardon?
Yes.
Yes.
Yes. You take the date from the court master. Yes.
Obliged, Lordship.
Yes.
My lord,
Have you served?
I crave my lord's indulgence. My lord, there was little I apologize. I seek my lord's apology. KHDC has actually stayed the referendum, my lord, which I was not aware.
Sorry, stayed.
We are, in fact, seized with the matter. I took instructions, and I found out that on the 31st of July, we have issued a letter saying, and my colleague, I think he has got a copy. Let him give to the court.
On the basis of that, my lord, I will
You have to withdraw your case. That's-
withdraw, my lord. On the
No, matters.
My lord, I'm extremely sorry. I wasn't not aware, and after the matter was that they informed me. I was calling them. They informed me that they also received, so they immediately forwarded me in my WhatsApp.
See this order.
With cause, Your Worship.
No, this statement heard Mr. P. Yobin. Stop for the petitioner, Mr. V.G. the special counsel is present on behalf of
Respondent
the respondent's number
1 and 2, my lord.
1 and 2. Stop. It is informed at the outset that the cause of action presently does not is absent in as much as the proposed referendum scheduled for 3/8/2024 since been stayed by the respondent number 1, 2, 3. 1 and 2.
1 and 2, my lord.
Yes. Sorry, matter stands closed. Yes.
My lord, I'm deeply obliged, and I apologize, my lord.
You're a seasoned counsel.
My lord.
But the problem is all these clients now, they're over smart. They don't tell the lawyers.
My lord,
I've seen that become, even Mr. Sangma's facing same fate.
My lord.
Matters pending before this court,
My lord.
they go and make media give
Public
interview with pictures and everything. Matters been listened, not been heard. And that is...
Even this matter, my lord, I have asked them many times. Have you?
They
Why
know
don't
they're
you
over
approach?
smart. Sometimes they don't tell the
My lord.
law counsel.
They want cheap publicity. Cheap publicity.
Obliged, my lord.
Your Lordship, I really regret and I beg to apologize.
It's not your fault, Mr. Lusoma.
I have asked my client, I just called just now my client. He didn't say that 20 times or this thing.
It came in the
He didn't
papers.
say. It didn't.
That'll be
it came.
produced. We will take record.
It
We will
came.
take judicial notice.
So I beg apology.
You
on
can't
my
beg
client.
apology. It's not your fault. What will have to do, what have to do. Yes.
My client also is
Thank
here.
you.